Some of the coup defenders are losing again today. The January 6th committee basically winning around, as a judge finds, Donald Trump signed legal documents knowingly, meaning he shared false claims that he knew were false, basically a legal way of saying he was lying. What does it mean? Well, they're ordering Trump lawyer John Eastman, who we showed you getting searched a moment ago, to turn over even more emails to the January 6th committee, which is still doing its work. Now, that's bad for Trump because, remember, most of your contact you have with a lawyer remains privileged, even if you're talking about really bad stuff, incriminating stuff in the past, unless you're trying to commit new crimes together. It's a high bar, even if you're not a former president. But the judge found the email evidence here has a sufficient link in furtherance of a conspiracy to defraud the U.S., with Trump knowing the specific numbers of voter fraud submitted were wrong as he continued to tout those numbers in court and to the public. Here's why this is a big deal. We never know exactly what the DOJ is completely up to, but we followed some of these threads in the January 6th committee, which often are clashes about evidence, just getting the darn people to do their duty, to comply with a lawful subpoena, to testify, or in this case, to separate out what I mentioned. The legit privilege stuff, Donald Trump, like everyone else, is entitled to that privilege. Any stuff that's about new crimes, like defrauding the U.S., game over. To get into exactly this big news and some other material, we have someone who's been in exactly these prosecutorial positions. He used to run the famed SDNY, David Kelly, and I should mention is also my former boss. Welcome back.
Thank you. Good to hear.
There's so much going on. If people don't do this the way you do for a living, they might think, oh, okay, more files running around. Is it a big deal if you have a judge say, actually, I'm canceling part of the privilege because it doesn't apply?
It is a big deal. You know, the attorney-client privilege is a big deal in itself, and it protects a lot of records in a lot of cases. There's always issues about attorney-client privilege. You always have, like, way in the background, hanging over somebody's head, a rain cloud. And that rain cloud is a crime-fraud exception. Rarely ever does that cloud burst. And the fact that this judge found it tells me, when I looked at the opinion, was, wow, I'd love to see those emails, because they really need to be pretty explicit about, really perpetrating a fraud.
And when you say perpetrating, I don't want to be too legalistic. We try to be plain English lawyers, best as I remember. But you're using the gerund, the ing,
Yeah.
perpetrating, because to be very clear, if you're just saying, hey, remember a year ago, what you did on the taxes, talking to your lawyer, I'm worried that what I did before, I might have done wrong. That's not crime fraud, right? It's got to be what you're doing now or in the future.
Yes, it's really using the communication with the lawyer as kind of part and parcel of the commission of an offense. A crime.
A crime. Wouldn't Eastman know better? Shouldn't he know better?
Well, he's the lawyer. Yeah, he should know better. So it's really interesting, the fact that the judge found, in the thousands of documents, I think the most recent really comes down to clearly, nearly 600 documents or so, and that he found several of them to be, not covered by the privilege because of the crime fraud exception. It's a big deal, and I think that it's a big deal for the hearings. But it's really information. Your next question may be, can this be used against Trump in, say, a criminal prosecution?
Or Eastman.
Eastman, yeah, I think Eastman is probably, but I need to look at the emails.
What are you going to say, he's toast?
I think it could be, but the problem with emails of this nature, or that, using them in a court of law, in a trial, you have the thing called the hearsay rule,
sure,
rules of evidence. And depending on, he could be talking about what Trump knew to somebody else, communicating, because we know that Trump doesn't use email, right? So you know that he's not a party to this email. So Eastman is talking about what he may have said to Trump, or what Trump may have said to him. That's going to be hearsay in a criminal trial, most likely.
But let me push you on that, David. If you were working this case, and Andrew Weissmann, who had your job, has done this kind of thing and said, you got to work your way up, right? Yeah. They haven't hit any elites, what Liz Cheney said last week. They haven't hit any elites or Republican or White House officials for what seemed to be a pretty organized coup plot. If you hit Eastman, maybe you don't get to Trump, as you say, on hearsay, but if you hit Eastman, it seems to be the judge is looking at him going, looks like you weren't defending your client, looks like you were criming with your client.
Absolutely. But my only point is, I think this is really important information. The question is, how can you use this information? For the purposes of the January 6th hearings, I think it's really important. Big question about what did Trump know and when did he know it and what did he do about it? They may be lying right in those emails.
Yeah.
All right. So now if I'm Merrick Garland, it's a little bit more of a challenge about how I can use those emails. And it's hard for us to talk about that here without looking at these emails and understanding between who they are, the communications are, and some other contextual issues to determine how you can use them consistent with the rules of evidence.
And again, given your experience, final question.
Yeah.
Let's say, for maximum fairness, sake of argument, let's say Eastman had no knowledge of violence or plotting of that nature, that he was just working, obstruct, hinder, delay the certification, perhaps submit fraudulent materials like elector fraud, perhaps override the vote in these other ways, governmental, but apparently stealing an election. Would you see that as a conspiracy to defraud the U.S. case you could bring against him?
Yes.
Yes.
Yeah. I mean, again, there may be some prohibitions depending on the particular communications, but the short answer to your question is yes.
Yeah. David, good to see you as always.
You too.
Appreciate it. Hey, I'm Ari Melber. Thanks for watching The Beat. I wanted to let you know I'm writing a foreword to the January 6th committee's full report, which is coming out soon from HarperCollins. You can go pre-order the book right now, and it'll come to you first when the report comes out in the fall or whenever the government releases it. Just search Melber Jan 6 on Amazon or your favorite independent book site and click pre-order. You'll be the first to get both the report and my new piece on the coup conspiracy. You can also go to melberbook.com and order it there.